Hi there, and welcome to the Employment Law Show. John Scholes and the guy with all the brains of the operation, Lior Samfiru. Welcome to the show. If you're joining us for the first time, we talk about disability law and workplace rights. So stick around. The next 30 minutes is really important stuff. Lior, got a ton of stuff to get through today. We're going to get into the top myths of termination and something we call the Pocket Employment Lawyer. That is a very useful website and or tool. We'll get to that in just a bit. All kinds of things on the show, but we always start the show with the week that was, stuff that's been happening for you in and around the firm. You got a couple things to talk about.
I do, and it's always great to be here to talk about employment law. We reach a lot of people with this show, and that's terrific. I want us to get that message spread out that there are rights, there are entitlements, and there are good laws to protect you at work if you have a workplace problem. Many people don't realize how good the laws are. So if you have a workplace problem, I almost guarantee you there's a solution, a good solution. So we'll talk about that on every show. And if you want to always connect with me off air to talk about your specific situation, don't hesitate. We'll give you my contact information. You can call, you can email. We can sit down and go over it and solve those problems. But week there was a situation that came across my desk over the past couple of days. So I spoke with a lady. She had worked at the same job, an administrative position, for about 8 years. Well, recently the company decided to cut some costs. And in doing that, they had to let other people go. Well, the job still needed to be done. So what they did instead is they gave her these responsibilities. More work, a lot more work. So she went from working 9 to 5 to working 12, 13 hours a day. She'd have to come in on the weekend sometimes to catch up. The job she had was completely different from the job she was now doing. And it eventually got so bad, John, she had to go on a disability leave. The stress was just too much. She called me almost desperate, saying, what do I do? Do I have to go back? Just thinking about going back to that situation makes me feel even worse. So here's the thing, John. The company here, her employer, changed her job. Now, they may not have demoted her. They may not have reduced her pay, but they changed the job. They took a job that she had and doubled it or tripled it. Right. It's a different job. Our regular viewers know that we call that a constructive dismissal. So she now does not have to go back into the situation. She can treat the situation as a constructive dismissal and leave with her full severance, and that's what she's going to do. And I wanted to bring this up here to remind you, employers, employees, that if your job is now being added to, you're doing a lot more work, they've added responsibilities, someone else's job is given to you, and now you're trying to do 2 jobs. That is not something an employer is actually allowed to do. You may be able to treat that as a termination. You don't have to accept that. If your employer won't allow you to do your old job, you may be able to leave with severance. If that happens, you got to reach out to me.
If you end up in that situation, though, is there not a certain amount of time where you could be doing these other, in this case, added duties, and you have deemed accepted it, now you can't go back on it, right?
Absolutely. And the longer you do this, even though you may be struggling, you may not be happy doing it, if you continue doing these new duties, this new job, you're going to be considered to have accepted it. Now, in some situations, that could be a few days, a few weeks. Generally speaking, the sooner the better in terms of acting. You don't want to sit on your rights, especially not when your job is being changed.
Good way to reach out, employmentlawyer.ca. Check out the website. There you will find a way to find our live employment law radio show as well. From that show, we take phone calls from it, play them back here, and we talk about them. We comment on them. First call of the day is right now.
I was working for a company, and while I was working there, I needed some accommodation for a disability that I have. I provided 2 doctor's letters stating exactly what the accommodation needs were. The employer said that they would meet those accommodations, but they never did. And then they just terminated me the same day. I brought the second doctor's letter to work. They gave me my 1 week's pay under the Employment Standards Act.
This employer did nothing right.
John, we were both grimacing as we were listening to this. They didn't do anything wrong. They couldn't have done anything more wrong than they did. It's completely ridiculous. So let's break this down. So he asked for accommodation. He had a medical issue, required accommodation. The employer has a strict duty to provide that accommodation. They have to. Under the Human Rights Code, an employer has to accommodate a medical condition, a medical disability. Maybe that means modified duties, modified hours. Maybe that means ability to work from home. They have to provide that accommodation. Well, this employer didn't. So right off the bat, we have a human rights violation, failure to accommodate. But that wasn't bad enough. Why would it?
Right.
So what this employer does is it goes out and terminates this person's employment. You cannot do that. You cannot let someone go because they're sick or because they need accommodation. That is an even more egregious human rights violation. So we have human rights violation, and of course they said, here's a week's pay. Now, I don't know all this guy's particulars, but I can guarantee you he's going to be owed a few months' pay, not a week's pay. So an important reminder here for everyone, all our viewers, your employer has to accommodate your medical condition. They have to. If they don't, that's a human rights violation. You cannot be let go because you're injured, because you're sick, because you need accommodation. If your employer does that, you have to reach out to me right away.
Is there a threshold where an employer possibly can't eventually meet some sort of accommodation where they're kind of let off the hook, for lack of a better word?
In some situations, it's just too difficult to accommodate. They may be too expensive or just not workable. But remember, John, that is a very high standard. It's not enough for the employer to say, yeah, that's tough. Tough is not tough enough. It needs to be so difficult that it's just unreasonable. And in my experience, most employers say, no, we're not going to do it well before they should. So remember, you need and you have the right to be accommodated if you have a medical condition.
PocketEmploymentLawyer.ca. If you have not been there, check it out again. PocketEmploymentLawyer.ca. Give me some details on what it's all about.
So we've been using SeverancePayCalculator.com for years now, and over 500,000 people have used it. SeverancePayCalculator.com calculates the amount of severance that you've lost, easy to use, etc. Well, we wanted to take that ability, that technology that allows you to find out about your rights and apply it to more things. So I created PocketEmploymentLawyer.ca. Again, PocketEmploymentLawyer.ca. It's a tool that allows you to find out about your employment rights. Whether you've been terminated and you want to know how much severance you've received, whether or not you've been constructively dismissed. It allows you to find out if the employer has cause to let you go. It allows you to find out if you're an employee or an independent contractor. Spoiler alert, you're not an independent contractor. Right. And other things as well. So it does about 6 or 7 things, John, that allows anyone to find out about their specific situation. You go to PocketEmploymentLawyer.ca, you pick the category that applies to you, whether it's constructive dismissal, termination for cause, disability, and you answer some questions, and then it's going to tell you, yes, you've been constructively dismissed. Yes, you are an employee. You're not an independent contractor. It's having an employment lawyer with you on your smartphone, on your tablet at all times. Check it out. It's free. It's anonymous. It's easy to use. There's no strings attached. If you want to, you can contact me directly from PocketEmploymentLawyer.ca. The very first place you should go to, even before you call a lawyer, is PocketEmploymentLawyer.ca.
It really is kind of cool. It does so many things. But again, one of the glowing attributes, and right at the top of Pocket Employment Lawyer, is the SeverancePayCalculator.com. In fact, you go to PocketEmploymentLawyer.ca, it will take you to the Severance Pay Calculator, which, as you said, over 500,000 people have used it. It's always best to run a scenario through the calculator and see what we come up with. And here it is. 56-year-old Jerry successfully managed a team for many years. After a new VP was hired, his results were called into question. All right, he was put on a performance improvement plan. A few weeks later, the VP said it wasn't working and let Jerry go for cause. No severance, of course. That's what this comes down to. He'd worked there for 10 years, earned about $102,000 a year.
So there's 2 issues here. Number one, is there cause to let him go? Is there cause to let Jerry go given this situation? Number one. Number two, if there isn't cause, how much severance is he actually owed? So PocketEmploymentLawyer.ca would allow you to find out, and for both of these questions, what the answer is. So let me tell you what the answer is, and then let's use the tool in action. So just because Jerry may have had bad performance, it does not mean he can be let go for cause. Bad performance does not equal termination for cause. It's extremely difficult to terminate someone for cause. It's reserved for the worst offenders. So even though he may have been on a performance improvement plan, even though his performance may not have been great, maybe it was, maybe it wasn't, it doesn't actually matter. Right. It's not a for-cause termination, which means, John, he is owed full severance. That may happen to you. You may be put on a performance improvement plan. You're still going to be owed severance if you're let go. So let's plug that into PocketEmploymentLawyer.ca or SeverancePayCalculator.com and find out how much Jerry is owed. So he's a middle manager. Worked there for 10 years. You can see that on the screen. 56 years old. We know he's making $102,000. He wasn't given severance because he was wrongfully dismissed. Well, the severance calculator correctly determines that he's owed 14 months' pay. At his compensation level, that's almost $120,000. So he's been wrongfully dismissed. He's owed 6 figures. You may not be owed six figures, but you may have substantial entitlements. That's why it's so important to go to pocketemploymentlawyer.ca.
Still to come here, lots of good stuff. Top Myths of Termination is on the way again. Pocketemploymentlawyer.ca. That's where you find the severance pay calculator once again. Hey, you want to reach out by phone call, 1-855-821-5900 as well. The Employment Law Show. Stick around, lots more coming up.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, and welcome back to the Employment Law Show. We got a list. We usually get a list every week of something we do in the show. Now, this one took a little while to whittle down from like 100 down to just a top few. So we'll get to that. The top myths of termination is what we want to talk about here. I'm going to get right into these, Lior, and you can expand on them. Number one, your boss can only let you go if they have a good reason to let you go.
So remember, these are myths. These are misconceptions. These are things that are not true, but despite them not being true, so many people believe them. I get asked that all the time. Well, for example, what you just said, isn't it true that I can't be let go, or there has to be a good reason to let me go? And I get a lot of individuals calling me very upset that they were let go when there really isn't a good reason. So let's demystify this and let's tell you the truth. So your employer, unfortunately, depending on your perspective, can let you go at any time and pretty much for any reason. It comes down to having to pay severance. You don't have to have done something wrong. Your employer can still let you go. There could be no reason whatsoever. The blue car example, you've heard me use this before, is my favorite example. Your boss can say to you, you drive a blue car. Last night we decided we like people with red cars. So silly, ridiculous, right, but legal. Your employer can do that. So you can be let go if you've done nothing wrong, but, and this is a big one, your employer has to pay severance. And in most cases, John, in most cases, over 90% of the time, when people are let go, they're not offered anywhere near what they're actually owed, which makes it a wrongful dismissal. That's why we focus on severance so much on the show, because ultimately that's what the law does. It talks about compensation, so you're owed severance, but you can't be let go for any reason, of course, as long as it's not discrimination.
And coincidentally, it's always the first phone call after they've been let go. I did nothing wrong, they can't let me go.
Yeah,
or
they said I did something there which I really didn't, so it's wrong. No, at the end of the day, as long as you get severance, legally speaking, that's what matters.
We're talking about the top myths of termination. Number two is this, when you're let go, you receive, 1 or 2 weeks of severance pay for every year of service.
The old, week per year.
Week per year.
That is a huge myth. It's probably the reason why we started this show all these years ago. It's wrong, it's false, it's not even close. It's not a week per year. It's not 2 weeks per year or any other per year, okay? It's simply not. It's based on a number of factors. Your age, your position, and the length of your employment. The longer you work, the older you are, the more senior a position, the more you're owed. It's as simple as that. So because of that, there's no direct formula. But here's the thing. Most people are owed a lot more than a week per year or 2 weeks per year. Most people are actually owed more than a month per year. So that's why it's so important to go to pocketemploymentlawyer.ca or severancepaycalculator.com to find out how much you're owed. It's easy, it's simple, but it's not a week per year.
You can reach out as well, help@employmentlawyer.ca through email. There's another way to contact. We were talking about the top myths of termination. Number 3 is this: you have to work at least 5 years for a large company in order to receive severance pay.
Huge myth. Or only certain people get it, or only certain companies have to pay it. No, nonsense. You get severance if you work for a small mom and pop shop, and even if you work for a month, you're still owed severance. Okay, and I said that, even if you work for a month. Not only that, you may be owed even more severance if you work for a short period of time. So everyone gets severance. Again, age, position, length of employment, severancepaycalculator.com and pocketemploymentlawyer.ca works. So no, it's not true. You don't have to work for a large company or have a minimum number of years to get severance. You lost your job, you're owed severance.
Our top myths continue here. Number 4 is this: being on contract means you don't get severance pay at all.
We've touched on this before. Being on contract, usually I refer to this as being called an independent contractor. Nonsense. That doesn't work that way. Most people, if they have a job, they're probably misclassified as independent contractors. If you have a job, you go to work, you do your job, you come home, you come back the next day, do the same thing, you are, in the eyes of the law, an employee. It doesn't matter what the piece of paper you sign says, doesn't matter how you pay your taxes, doesn't matter what you actually believe that you are. The law makes that determination, which means if you lost your job, even though you're supposedly on contract or an independent contractor, you're still owed severance. And to find out, for your specific situation, if you really are an employee or an independent contractor, as I said before, pocketemploymentlawyer.ca, it works very well.
The plumber, the HVAC guy, those are independent contractors.
Sure. You need an electrical work done, plumbing work done. You call a plumber, call an electrician to your house. They're not your employees. They come there, they fix the job, they leave, they go somewhere else, do work somewhere else. Right. Those are independent contractors. But if the electrician came to your house every single day, worked 9 to 5, came back the next day, worked 9 to 5, you told them what to do, when to come, how long to work, at that point, they would become your employees. So are you the plumber? Are you the electrician? Are you something else? If you're something else, you're an employee.
Top myths of termination. We'll get to the last one here. Is this: short service employees get very little, if any, severance.
I touched on it before, but I think it bears repeating. There's this misconception that just because I work for a short period of time, I get little or maybe I get no severance. Not true. Not only is it not true, John, short service employees get disproportionately greater severance than longer service employees. You may have an employee that's only worked for a few months who may be owed a few months severance. You could have worked for 4 or 5 months and be owed 4 or 5 months severance. So short service does not mean little severance. It certainly doesn't mean no severance. If you lost your job, you're owed severance. And last time, I'll say this now, pocketemploymentlawyer.ca to find out how much you're owed.
Again, our employment law radio show, live radio show, we take phone calls from that. We play them back here on TV, and we talk about them. Second phone call for this show is coming up right now.
I recently got laid off from my job. I just want to know if I got the right amount. I worked there about 6 years, 8 months. It was a private medical company, so I worked as like an OR assistant.
And how old are you?
42. I didn't sign off on anything when I left, but I did have an employee agreement.
Yeah, and very common situation, John. When someone contacts me after they lost their job, they're offered something, they want to know if it's appropriate. So he said he signed an employment agreement. In some situations, an employment agreement may try to limit your termination entitlements. It's very important to pay attention to that. But just because you signed an employment agreement that tries to limit your entitlements does not mean that it's actually enforceable. Does not mean that it has the effect of limiting your entitlement. So let's talk about this specific person and their specific situation. Let's plug the information into severancepaycalculator.com to find out how much he's actually owed. So we know this individual was in a technical role, been there for 6 years, 42 years of age, and he was offered very little severance. Well, here's the thing, John. 8 months is what he's actually owed. 8 months pay. And for him, let's assume he's making $62,000 a year. That's over $40,000 in severance. So he wants to know how much he's owed. Even though he's only worked there for 6 years, he's owed 8 months pay. That's more than a month per year. That's what I said before. It's not a week per year of service or 2 weeks for most people. Like this person, it's a heck of a lot more. So check it out for yourself to find out how much you're owed.
What do you do when you're asked to accept a temporary work relocation? We'll drill down into that after a short break. You want to reach out, 1-855-821-5900. And don't forget, pocketemploymentlawyer.ca as well. Lots more of the Employment Law Show is on the way. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back to the Employment Law Show. John Scholes, Lior Samfiru. This is part of the show, again, where we take another phone call from our live Employment Law Show on radio. We get a ton of calls each week on the show. The interesting ones, the ones that we can drill down to, is really where we focus. So, Lior, we'll get to phone call number 3 for today's show right now.
I'm in a situation where I work for a company and I was asked to go to another location, and it's another hour and a half from where I live. So I did that for them for a little bit, and then they've asked me to go there full-time, gave me compensation of $60 a week for gas. And they said, well, this will last a month. Now, every month they've said, oh, it'll be another couple of weeks. I've only been with the company for about a year. It's just getting a little much on the family life, you know, and my wife telling me to get a new job. So I'm just curious where I stand on that.
Yeah, it's a tough situation, and I'll explain why he probably made it tougher for himself than it needs to be. So let me explain this. Let's start with the idea that your employer does not have the right to relocate you. Certainly not to the extent that now you're going to travel an extra hour and a half to
3
get to
hours
work.
round trip.
3 hours round
Crazy.
trip. That's massive. That's lifestyle changing.
Yes.
It's huge. So if your employer does that, you can obviously accept it, or you can choose to treat this as a termination. It's a constructive dismissal. It's probably one of the easiest forms of constructive dismissal to prove, because all you have to show is, I used to commute 20 minutes, now I'm commuting an hour and a half, done. It's a constructive dismissal. Your employer cannot do that. Now, if I have one concern for this person, is the fact that it's been happening for a while. He's been doing this for a while, and he's being the good soldier, he's allowing that to happen, and then obviously it's difficult for him. That said, because his employer keeps telling him, oh, it's only temporary, he should still be able to treat this as a constructive dismissal. But the lesson here is very, very important. If your job changes, in this case, if you're being relocated, you can try it out for a short period of time. You don't want to try it out for too long, because if you do, you may be considered to have accepted it, and now you can't do anything about it. So we said this is a constructive dismissal.
Yes.
We know he is owed compensation, severance, because of this constructive dismissal. So let's go to pocketemploymentlawyer.ca to find out how much he's actually owed. So we know he's been there for a year. I said maybe he's a professional. I picked an age. And the severancepaycalculator.com or pocketemploymentlawyer.ca correctly says, you can see that on the screen, that he's owed 4 to 6 months' pay. Now, John, he's been there for a year and a half. And even after a year and a half, he could easily be owed as much as 6 months' pay. So that's what's at stake for him. So remember that. But also, if your employer changes your job, in this case, changes location, you don't have to accept it. You can try it out for a short period of time. Otherwise, it's a constructive dismissal.
You mentioned try it out. Is this something you would put into writing with your employer, saying, I want to muck in, I want to be the good soldier and help out. Let me just take this for a spin, literally, for a little while. But if this doesn't work with my family situation, I'm not doing it.
Yes, if you're going to try it out to see how it impacts you, it's a very good idea to tell your employer that's what you're doing. To send an email. Email works beautifully, saying, I'm concerned about this move. I'm concerned about how this is going to impact me. I will try it out for the next few weeks and then let you know what I think.
Good call.
Because if you do it that way, you're preserving your right to try it out. You're preserving your right to treat this as a constructive dismissal. So that's a very smart way to go about it.
Another resource for you to reach out, ask questions, get information, terminationquestions.com. Terminationquestions.com. You can go there, ask your questions, or answer quite quickly. Chance is, or there's high chances anyway, that your question has been asked and answered in detail. There's a drop-down menu there, but I will get to one from terminationquestions.com, brother. Says this, my manager just handed me a new employment contract, we love those, with a deadline to accept it within 48 hours or my job will come to an end immediately. I noticed that the contract reduces my commission. Do I have to sign it?
So let's be very clear. This person is quite wise to be concerned about that, because not only does the new contract reduce commission, I haven't seen this contract yet, but I can almost guarantee you, I can actually guarantee you that it does other things that are unfavorable, potentially limiting her future severance, potentially giving the company the right to make other changes to employment. So as a rule, and I've said this before on the show and I've said this before on the radio, when your employer wants you to sign a new employment agreement, all of a sudden, don't do it. It's bad news. They're not offering you something that's better. Even if it looks on the face of it that it may be okay, I assure you, in the fine print, it's going to hurt you in the long term. So don't do that. Now, can she be let go for not signing? Remember what I said before. She can be let go for any reason. So her employer can let her go. But John, in some situations, it's better not to sign the contract and be let go than to go ahead and sign it. And let me tell you why. If her employer lets her go right now, they'd have to pay her full severance. Okay, that's fine. Based on her commission as she's earning right now. If she signs the agreement and 6 months from now, her employer lets her go, well, number one, her severance is going to be calculated on the basis of the new commission, so she's getting less. And also, she's going to get a lot less severance because that agreement probably limits her severance. So she could lose tens of thousands of dollars by signing this agreement. So in some situations, you are better off not to sign an agreement. Say thanks, but no thanks, even if it means losing your job. And if you're not sure if you should sign the agreement or what it says or what it does, call me, send it to me, let me review it, and let me tell you what it all means.
Again, terminationquestions.com is the resource for these questions. Next one is this. We'll slide this one in. It says, a new coworker has been making inappropriate comments in the office. I've asked him to stop a few times, but things keep escalating. What are my options here?
So this is obviously a form of harassment. If you're being subject to inappropriate comments, inappropriate behavior by a coworker, that's a form of harassment. And harassment is not acceptable. You should never have to endure in a workplace that is harassing you. You have a right to work in a safe, in a productive, in a supportive work environment. And if the work environment becomes poisoned, you can treat that as a termination. You don't have to accept it. So as a first step, what I would do here is I would go and tell about the situation or report the situation to someone in a position of authority. Maybe an HR manager, a boss, an owner, someone that has the ability to do something. Because once you tell them that you're being mistreated, that you're being harassed, your employer has a few obligations. The first obligation is they have to take it seriously. Right off the bat, they have to take it seriously. They then have to investigate, to take all reasonable measures to investigate what happened. And if there's harassment, they have to then fix that problem. They have to make it go away, whether that means disciplining someone, letting someone go, having better, stricter policies. Either way, they have to do something. So give the company the opportunity to fix the problem if you're being harassed. If you've tried and nothing's happened, or maybe there's no one to talk to because the boss, the owner, is the one actually harassing you. Well, at that point, we have to deal with it externally. By that, I mean, talk to me, call me, email me, and let me get you out of there with compensation. Don't stay in an environment where you're being mistreated or harassed. It's going to impact your health. It's going to be a very bad thing for you long term. So it may be time to get you out of there.
Pocket employment lawyer. I love this. Give it to me again. It's so good.
So if you want to have that legal advice with you at all time, want to know more about your situation, want to be armed with power and information, pocketemploymentlawyer.ca. You have that on your phone, on your tablet, on your desktop with you at all time. It's like having me or one of the members of my team with you always. You go to pocketemploymentlawyer.ca and you have a number of scenarios that it can help you with. Constructive dismissal, termination for cause, disability, human rights violation, severance, and more. So take it up for a spin. Try it right now. Go grab your smartphone, go to pocketemploymentlawyer.ca and use it. Find out about your rights before you even call a lawyer. No need to worry about it. Simply go to pocketemploymentlawyer.ca and check it out.
All your colleagues are going to love you for this one in the law business. Really? Don't call a lawyer anymore? Really?
I'm not going to be popular at the next lawyers conference.
No kidding.
Like, you're the one that created the pocket employment lawyer. Now people are not calling us as much. Exactly. That's okay. I want people to have information. That's all. I'm all about access to information. So if someone doesn't want to call me, that's okay. They should still have that information. That's why I created pocketemploymentlawyer.ca.
And through that, again, you can reach severancepaycalculator.com as well, where you should go there first, even before calling Lior. To reach out anytime as we wrap it up here, 1-855-821-5900 and employmentlawyer.ca, or simply help@employmentlawyer.ca through email. Thanks for joining us. Hope you got a lot out of it. We'll do it again and again and again till you know everything that he knows. Right here in the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.